Greetings, my fellow Americans, and welcome to another episode of the Great Montana Conspiracy Podcast. Tonight we're going to be talking about civil regulatory schemes, and that's not going to be a very popular topic amongst a lot of people, but it does need to be talked about. It's really important, and it's important because it's a lot of ways that the Great Montana Conspiracy keeps their tabs on me, and I'll explain that as I go along. But first, before we go any further, if you're watching this on YouTube, would you please take the time to like and subscribe, and of course, any platform in which you're watching this, please take the time to share this with your friends and family, associates, anyone who might benefit from this information, or take this information and actually possibly help affect change. The more people that know, the more people that are aware of this, the less influence people who promote propaganda and misinformation have. That being said, before we actually get into the topic, and I'm actually take a slight moment aside and take a personal plug. A few weeks ago, I actually published my 25th book. It is Stranger's Silence, which is this book right here. I just received my first print copies today, which is why I'm taking a moment to take it aside. On January 15th, I published this book. It's the final book in my Chaos Rising series, which actually consists of that book, Stranger's Silence, Terranel's Song, and Immortal's Discord. This is actually a book that was 30 years in the making. I first thought of the story back around 92 when I wrote the prologue as a short story. My son was just barely a year or two old at that point in time. I wrote it into the first novel, Terranel's Song, which I actually completed in 98. I thought I lost it in a house fire in 99. I thought the first novel I had written was gone. I happened to recover it on a lost copy of a disc that I found in 2010. There were some floppy disks that had survived the fire, and I just happened to be going through them and seeing if I could restore any data off of them. It wasn't even the story I was looking for, to be honest with you, when I came across a corrupted copy of the story. At that point in time, it was originally I wrote the story as Elminster's Song, which was actually intended for the TSR universe. It was rejected by TSR, but it became Terranel's Song. I rewrote the book, brought it into a modern context, merged it with the story of the universe I had already created through Neril, which was the setting for the Godslayer cycle, which I had published just a few months previously. And I actually published it in 2012. It became my second published novel, even though it was the first novel I actually wrote. As of November 2011, that marked my 10-year anniversary of publishing. I've actually been publishing books now for over 10 years. This book was published, my third book in the Chaos Rising series, was published on January 15th, 2022. But due to the delays of printers, age of COVID, ladies and gentlemen, I just received the print copies today. All these books, of course, are available on Amazon. You can always find these books through my website, which is ronglick.com, RONGLICK.com, or you can search for Ron Glick on Amazon and find me there. Of course, anyone who wishes to purchase these books in support of this ongoing podcast, please take the time to write to me. You can write to me at ron_glick@yahoo.com, and there you can instruct me, let me know you're purchasing the book, what you're purchasing, and that you'd like the proceeds to go towards the support of this podcast. I'm more than willing to do that. All proceeds of my autobiography, U.S. Political Prisoners Since 2004, do go to support this program, though. That's another book you can look for. Remember, I have 25 publications. I have 11 novels, 12 trivia books, and 2 nonfictions, one of which is the autobiography. So please take the time to support me, either directly contribute to support this program, or support me through my books, my publications. It'd be fantastic, wonderful, and I do hope you at least enjoy the stories. I'm always looking for feedback on them. This said, now we're going to go into tonight's subject. On this episode, we're going to talk about something called a civil regulatory scheme. Now, like I said, this is not likely to be a popular topic, because this term is applied almost universally in the modern sense to sex offenders and violent offenders. But I want to make clear up front, I'm in no way endorsing sexual misconduct or sex crimes. I'm not suggesting in any capacity whatsoever. that sex offenders or violent offenders should not be punished, or that their conduct is excusable, it's acceptable, or anything else. Nor am I lobbying to non-criminalize sex offenses or violent offenses. I believe that any crime, regardless of its type, does deserve to be effectively and within parameters, fair and equal parameters, be punished. But I'm also a very strong advocate of double jeopardy law. And most people know double jeopardy as you cannot be tried twice for the same offense. But people forget the secondary rule, which is you cannot be punished twice for the same offense. And what this constitutes, the civil regulatory scheme amongst other constitutional deprivations, is a continuing and perpetual punishment that runs side by side with any other punishment that's dealt out. So this really needs to be examined, not only because it's a horrific application and sidestepping of constitutional law, but it represents the method by which that Montana has used to try to keep track of me. This is a way to track political prisoners. This is a way to track people who are considered disfavorable or political upstarts. Anyone who the government decides needs to be tracked, needs to be followed, needs to be kept tabs on, they can simply classify them as a sex offender or a violent offender, and they automatically get the right to track them for the rest of their lives. It doesn't matter whether they're actual genuine sex offenders or they're just classified that way. It is a way to hide the government's intention to track political dissidents or people they consider to be too outspoken, too much. They're pains in the butts to the corrupt authorities as they exist, as I am. But regardless, there's a very common expression I often run. It comes from a Supreme Court case. Wick Ho, you can look it up. But it says that a law, regardless of its purpose, when applied with an evil eye and a wicked hand, is unconstitutional. So regardless of how much it looks like it's legitimate on its surface, the precedent set by Wick Ho says that if it's applied in a wicked with an evil eye and a wicked hand, that it can't be constitutional. So if there's a deliberately malfeasant intent to it, or if it exists for the purpose of malfeasance, or for persecution, or for segregation, or for whatever illegitimate reason, regardless of what its stated purpose is, it's unconstitutional. Now remember this as I go into talking about a Supreme case law here. I'm going to bring this back up. But like I said, remember, our country is supposed to be about serving penance. You serve penance, you do your civil duty, or you do your commitment you pay your debt to society, you pay your penance, you do your crime, you do your time for the crime you committed, and then you're supposed to be released back in the community to restart your life. Offenders of any kind deserve to be able to serve their debt to society and be done with it. They deserve the right to prove they've been rehabilitated. Should they be able to re-enter society, they should be able to do so without a label or any disenfranchisement. If you sell drugs to a child, kill and hide the body, no public registry. But if you pee in an alley, you're now guilty of public exposure, and you have to publicly register for the rest of your life. This is a seriously arbitrary end run around constitutional protection. And it must be called out for what it is. It is unconstitutional. It is not a civil regulatory scheme. It is a method by which to impugn a group of people for being disfavored, regardless of how you may see the crime, regardless of how horrific it is. And like I said, I am not in any manner, shape, or form justifying the crime. I'm not in any manner, shape, or form allowing for this misconduct or saying this conduct should be excused. I'm not. If you hurt someone, regardless of the way you hurt them, whether you're a wife beater, whether you steal from someone's car, whether you steal $1 million from somebody else, you're a criminal and you deserve to be punished for the crime you commit. Regardless of whether it is a sex offense or it is a business offense or whatever. Grand theft auto, you name it. If it's a crime, if you've committed the crime, you deserve to be punished. However, you deserve to be able to be rehabilitated, re-enter society without any stigma, without any kind of label hanging over your head. Now, if this civil regulatory scheme was purely a law enforcement method, I wouldn't be here. I wouldn't be making these arguments. But it's not. These are publicly accessible databases. Anybody on the internet can look them up. Their addresses are posted publicly. Oftentimes their jobs are posted publicly. The law enforcement, the registry requirements you have to register your vehicles, you have to register your source of income, you have to register your email addresses, what websites social identities you have on public platforms, and many times this information becomes public. In essence, you're basically taking a concept that says, okay, you committed a crime, and saying because by virtue of that crime, you are now forever lose your rights to privacy, forever lose your right to be shamed for what you did. You can never be rehabilitated. You can never demonstrate that you've paid your debt to society because you were always branded publicly for the commission of a crime, which you may have committed as a child. You may have committed as a 10-year-old. Many states require registry for life, regardless of when the offense was charged. Now, the United States Supreme Court actually has come down in a recent year and actually shot down a state's requirement that minors register for the rest of their lives as being too excessive. But there are other states who still have these laws who have not changed them just because the United States Supreme Court has ruled against it. It's not a good situation or a good circumstance, but it's unfortunately when in the United States, when they say the United States Supreme Court has declared this to be unconstitutional, the mandate only goes against the parties who are named in the complaint. So hypothetically, if someone is suing the state of Ohio and Ohio loses that judgment, only Ohio is required to change what they have done. Kansas, Nebraska, New York, California, Washington, they may have the exact same laws in their books. They're not required to change them. They have to individually be challenged. And they have to go through the system. They have to go all the way through. And they have to go through their own district. And then hopefully the United States Supreme Court comes back and will rehear their case. Remember, the United States Supreme Court hears, I think the last statistic I heard was 13% of cases a year. They hear next to nothing. They barely hear any cases, and primarily only the ones that have some clout. They don't rehear cases they've already decided. They don't enforce their rulings upon the country as a whole. So if the lower district courts don't uphold their judgments, even if it's a president, the laws stay on the books. So you have to keep this in mind as you're going forward and you understand, yeah, something may be considered unconstitutional in one case, but we have 50 individual states and a smattering of territories, all of which make their own laws, own rules, and everything else. And there's nothing in the federal mandate that requires them to undo them, even if the United States Supreme Court comes down and rules what they've made into a law is unconstitutional. So basically, in essence, a civil regulatory scheme is when a government imposes a civil law to regulate public safety. Seems pretty simple, right? I mean, as an example, Native Americans, tribes have been allowed to enact rules against non-tribal members for hunting, fishing, moving upon tribal lands. They've been allowed to regulate through civil regulatory schemes who can and cannot harvest off their lands. The problem is, violation of a civil regulatory scheme is almost universally a criminal offense. can be fined, do jail time, and in many cases, felonies, as is the case in most states for violation of a failure to register, whether you be a violent offender or a sex offender. It's a felony. It is a felonious act to not register. You can go back to prison for up to 10 years for just missing a registration or a technicality of a registration. As I was researching this story, and I wanted to put some examples of this, but there are just so many deplorable examples of people who, just a small technicality. Oh, I didn't realize I had to register before I left, my county and moved to another county. I report once I arrived at the county, but I didn't realize I had to register before I left the county. Well, guess what? Because you've acknowledged you're in another county, you're now in violation because you didn't notify in advance that you were leaving. Therefore, you're off to prison for 10 years. I mean, the rules are just so inane, and they vary with every single state because there is no consistency. Every state passes their own standards, their own rules, their own laws. Some are just absolutely draconian. Others just follow the bare necessities in order to get the public grants from the federal government. Remember the Prison for Profit? They get a block grant for criminal justice every year, and if they do not have this law in the books, they lose 10%. Right off the top, 10% of their criminal grants off the top if the states do not comply with this rule. And I'll explain the specifics of that in a little while. But regardless of the scheme, regardless of the reasons or the justifications, these schemes have been, these criminal regulatory or civil regulatory schemes, they should be criminal regulatory schemes. They're called civil regulatory schemes, or CRSs. They've been used to bypass constitutional law and mandates for decades. They violate Fifth Amendment law against double jeopardy. You cannot be punished twice for the same offense, and yet here you have a regulatory requirement that runs simultaneous with whatever sentence you're imposed upon. And oftentimes, as in most cases and in most states, it is a lifetime registration. You must register for life. You must post publicly where you are, what your offense is, etc., 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 for the rest of your life. It can affect your housing, your employment, your social engagements, who you can associate with in many cases. It violates the Eighth Amendment to the Constitution against cruel and unusual punishment. The United States Supreme Court has consistently come down on other issues and said life punishment is unconstitutional, that it violates the cruel and unusual punishment aspect, with the exception, of course, of murder. Life imprisonment for the taking of a life has been generally upheld by the U.S. Supreme Court. The idea being that it's not excessive if you take someone's life to lose your own life through life imprisonment. Whether you would agree or disagree with that, I'm not going to sit here and discuss, of course, but the idea is the United States Supreme Court has upheld that for the greatest offense, taking a life, yes, that lifetime imprisonment can be a justifiable punishment for it. However, anything else, anything that doesn't constitute taking a life, has generally been shot down as being too excessive, too extreme. The United States Supreme Court has shot down drug issues. It even shot down some issues dealing with, as I mentioned, a minor registration, lifetime registration, as being too excessive. But by calling it a civil regulatory scheme, that it somehow serves the interest of the community to register and publicize and shame these people for the rest of their lives, that somehow outweighs their constitutional liberty right against this. And don't forget, the due process clause of the 14th Amendment is also violated by this. You can't sit here and give somebody a due process claim if they're being required to register in advance of a crime they haven't committed. There absolutely is no way they can ever, in many cases, get off this list once they're on it. Most people in the United States, and I imagine if you're coming from anywhere in the United States besides the United States, this is going to seem a completely foreign concept because it's the only country in the world that does this. But most people in the United States are familiar with what sex and violent offender registries are. They're familiar with the laws. They're familiar that A sex offender must register where they live. Violent offenders must do the same. With a certain period of time entering a certain area or region or whatever else. I mean, like I said, this is unlike any other country in the world. No other country in the world does this but the United States. Like I said, keep in mind, you have to list your address, your place of employment, vehicles, email addresses. You must register any place you're residing for more than 3 days. You must report your intentions to leave or enter states, oftentimes leave or enter counties, or even communities in general. Essentially submit to a lifetime tracking of your whereabouts and the ability to find you. Once again, I remind you, political prisoner, keep track of, make them required. Require to register. Tell us where you are at all times. Doesn't matter if you actually are an offender. All you have to do is be called an offender and you're required to register. Therefore, they can track you under this auspice of we're protecting the community, but they're really protecting themselves because they want to be able to come after you if you speak out, if you say something inappropriate, if you go too far in exposing their corruption, they want to be able to come after you. Even if I manage to serve out the last 2 years of my so-called sentence that they won't relieve me from, even if I can get out of it without being revoked again, or them trying to revoke me again, I'm still required to register. I'm still required to go through this process for the rest of my life. Now, in Montana, they actually make it to where after 10 years for a level 1 sex offender, which is what I'm categorized as, that because I only have one offense, even the psychosexual evaluation said I had no indication of recidivism, no indication of a perpetual pattern of abuse. I allegedly touched my stepdaughter one time inappropriately. I've denied it. I've maintained my innocence for 18 years now, 19 years now, and I'm going to maintain my innocence for the rest of my life because I didn't do what I was accused of. But I'm required to register, and I will be required to register for the rest of my life. But like I said, in Montana, you are allowed to go to the court and say, hey, as a level 1 sex offender, I have been registering for over 10 years. I would like to be relieved of that obligation. But it's a discretion of the court. And anyone following my podcast knows I just applied for early release. I only have 2 years left on a 20-year sentence. 2 years. After 9 months of probation, under the current law, I would have been eligible for release. Every time I even brought it up, now mind you, when I was first entered into the system, you had to do 2/3 of your time. 2/3 of your probation time was after 10 years of probation, I could apply. Then they changed the law and they said, oh, no, now it's only 9 months. You can apply. You could have applied after 9 months. Great. They don't make it retroactive. But regardless, every time I brought it up, every time the issue came up, it provoked responses from my ex, Mara Mara Jafrida. It provoked hostilities and revocation threats. It provoked all kinds of verbal assaults against me, Craigslist, Facebook nonsense. It provoked hostilities and it intimidated me. Fair point, it intimidated me. I didn't want to go back to prison. I did not want to be revoked again, and therefore I held my tongue. I filed for it. Heidi Albright made the worst just libelous statement you could imagine to frame me as this dangerous person in society. I'm out here causing all these problems and blah, 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 somehow keeping me under the thumb of probation for the remaining 2 years of a 20-year sentence is somehow going to protect society. It's not in the interest of society or whatever. I argued it. Anybody who's following my podcast can look back at my podcast talking about Judge Heidi Albright. You'll see my pleadings. You'll see everything that's still pending, still waiting on a response from Heidi Albright about exactly why what she said was just absolutely wrong. It was fraud of the court. Absolutely was a misrepresentation of the record. It was a deliberate misrepresentation of the record to cover up and to set a story and a justification to continue to hold me. Now, if all I want to do is 2 years, get 2 years free, and you're looking at a lifetime imposition, Do you honestly think it's going to make a difference? I asked them for be released of a remaining 2 years of a 20-year sentence. They said no. They lied. They changed, misrepresented the record, created a horrific tale of somehow I'm the most dangerous person since Hitler. This is what they did. Now I'm asking you to be relieved of a lifetime obligation. Do you honestly think it's going to make a difference? Of course I'm going to ask. Eventually, if I manage to get out of here, I will ask. They're not going to give it to me. I've proven that point. I asked for a 2-year relief. They won't give it to me. They're certainly not going to give me a lifetime relief. Absolutely not. They're not going to give me that obligation. They're not going to free me of that commitment. And that's the problem is I've never met anybody who's had a requirement under Montana law to register who's ever been released from the registration requirement. Even those who petitioned it, I've never seen one. If you're listening to this and you actually know of somebody who's actually been relieved of their obligation to report or to register, by all means contact me. I would love to speak with them. I would love to speak with anybody who's actually been, but so far I've not been able to find a single case where anybody has ever been granted relief. Now keep in mind, a lot of the problem exists that most of Montana's records are not online. Unless it's the Montana Supreme Court, unless it gets that far. District court decisions just are not online. Therefore, and I don't have the means to travel around the state and look at every single docket of every single case, nor do I have the time to do it even in my own county. So keep all of that in mind. I don't have resources. I don't have the resources to go through and do all this. I don't have a staff. I don't have the ability to travel. I don't have the ability to go and petition records and information the same way everyone else does. Again, these are restrictions imposed upon me for a reason, because they don't want me to have this information. But the idea behind a civil regulatory scheme is that they can track you wherever you go. And you're required to do so. If they find out you have not registered, you get to go to prison for 10 years. Sure, that's not criminal. That's not a punitive act. Sure, no. Sure, it absolutely is. It's triggered by a criminal conviction. You don't sign up for this registration unless you are a convicted person, whether it be a misdemeanor or a felony, which means it is a penalty. That's a consequence of a crime. That makes it criminal. It has criminal consequences, felonious consequences, serving 10 years in prison consequences. It is not a civil regulatory scheme, yet that's how it's classified. Much of the personal information that's collected, as I mentioned, addresses, places of employment, vehicles, email addresses, a lot of it's posted online, regardless of the state, whether it's Montana or otherwise. A lot of this information is posted online. Anybody can get it. There's no right to privacy. It opens up offenders to assaults, both verbal and physical, to harassments, to provocations, to discrimination. There are stories, horrific stories all around the country, the United States, and they show up in my timeline from time to time, where people actually will show up and they will burn the lawns of sex offenders. They'll post effigies, or they'll post crosses, or they'll just, throw flaming toilet paper at the sides of their homes. They'll just file the front of their houses. They'll spray paint. They'll graffiti them. They'll just... I've known a story of a guy who had 3 axes buried in his door. 3 axes buried in his door. Thunk, thunk, thunk. We'll open the door. There's 3 axes in his door. You don't think this isn't threatening? And the reason why are they allowed to do that? Because this information is made public. It doesn't matter what the person did. If someone does not want them in their neighborhood, they are then become targets of harassment and violence. And there's no protection. Sure, oh yeah, we're going to find out who did this and we're going to go after them. Police departments don't do that. They'll just write and make a report and move on. They certainly don't do that in Montana. The problem is that most people are not aware of how consequential this civil regulatory scheme is. And the fact that it's almost universally applied to violent offenders and sex offenders makes it a class issue. Because this is an excuse and a way to work with prejudice around existing constitutional protections and liberties that are entitled to every citizen regardless of their offense. Now, and I mentioned this at the very part of the video, in order to understand why this even exists in our country, we kind of need to understand the history of it. Most people they're simply not aware of the history. They're not aware of the reasons behind this. They just accept it as a fact. Nor are they aware of the unconstitutional applications that I've been mentioning. But it all starts with a case called Smith v. Doe. And this is a United States Supreme Court case. The notation, by the way, is 538 U.S. 84. That'd be the 538th volume of the U.S. Supreme Court reports, page 84. It's a 2003 case. There was a 1994 Alaska Sex Offender Registration Act. Now, mind you, I should point this out to you. The reason why so many states almost universally adopted sex offender registration acts at the same time was because the federal government decided to pass a law called the Jacob Wetterling Crimes Against Children and Sexually Violent Offender Registration Act. It was also a 1994 law. Alaska followed up almost immediately to make sure they complied with it. I'm pretty sure from the sounds of it, they got wind it was coming down the pipe, it was going to be signed into law, and therefore they got busy on they rushed it. They rushed that law in. It was a 1994 federal act that compels states, all states, to create registries of sex offenders. The penalty for not complying was that you would receive a 10% reduction in block grants for criminal justice. Once again, remember, I pointed out in a previous video, look up my podcast on prisons for profit. There are billions of dollars that are given out to states every year through these criminal justice grants. They're block grants. We're going to give you money to make laws the way we want you to make them. That's how the federal government influences the states. They offer money. And they offer massive amounts of money. Massive. We're talking, like I said, billions of dollars. Billions of dollars. Not millions, not hundreds of thousands. Billions of dollars. Hundreds of billions of dollars go in to support this criminal justice system. Lose 10% of that across the board. That can cripple a state's economy, especially like Alaska. Alaska that relies heavily upon federal grant funds to be able to continue to operate its agendas. You lose 10%, that's a big deal. So the states fell right in line, passed them. Of course, once again, although the federal law made minimum requirements for these laws, the states oftentimes ran with it, and they ran hard, and they ran fast, and they went far beyond the original intent of the federal mandates. And this law, this federal law, was amended in '96 to require public disclosure of this information. Now, in Alaska, if not mistaken, I'm not sure whether the public registration was required as in the '94 application of the law, but by 2003, when this case came to the United States Supreme Court, it was a requirement. But remember, the only thing this law ever required was that it be a 10-year registration for sex offenders in most cases, except in case of violent sex offenders, it'd be a lifetime requirement. Almost universally, every state made it lifetime regardless of the level of offense. And remember, sex offenses are literally anything that involve nudity, public exposure. If you hit on a girl at a bar and she doesn't like it, hey, you put your hand on her shoulder and say, hi, in some states it's sexual assault. In some states, just looking at someone too long is a sexual assault. There's literally, I want to say it's New York, but I'm not sure it's New York or where, but there's a law in the books. I should have looked it up before I started this episode tonight. There's actually a law in the books that says you cannot look at somebody for more than 8 seconds, or it's a sexual assault. 8 seconds. So if you're looking at someone from across the room, and the reason why it comes to mind is because it was a comedian, and I can't remember which comedian it was on one of the talk shows, was saying, oh, 1, 2, 3, 4, 5, also, I could look at someone for 3 seconds and she says I looked at her for 8 seconds and I'm guilty of the law. I'm a sex offender. Many of these cases, sex offenders are oftentimes teenagers who, there's laws, for instance, in California. I went to school with a couple, and I've told this story many times. They've been dating since they were freshmen. California at the time, I don't know the current law, but back in 1983, in 1987 I should say, when I was graduating high school, the law was very strict. 17-year-old off limits, even for an 18-year-old. There was no year gap. There was no 2-year gap, 3-year gap. If you're 18, you cannot date anyone under the age of 18. These two have been dating and sexually active since they were teenagers, since they were 14, 15 years old. He turned 18 a few months before she did. And they got caught in the car having sex. He became a sex offender. It was perfectly legal for them to have sex prior to him turning 18, but the moment he turned 18, he became a sex offender. Got arrested, went to jail, the whole bit. It's not fair, it's not right, but that's what it was. And like I said, this is the issue. Anything can constitute a sex offense. It's not just the guy who finds a baby in the crib and performs some lewd sexual act on the baby. We're not talking about the guy who took the boy and girl into the wilderness and killed the boy and raped the girl and did so for weeks with impunity and then got found out and discovered. We're not talking about this level of offense, which is unfortunately how most people see sex offenders in general. They see anybody who's accused of a sex offense to be, that's what they are. If you're dating somebody who's just a year under you in school, why is that a sex offense? And yet, in many jurisdictions it is. Because it's a hot button issue. The point is that many states, and as I mentioned, Montana is one of them, took this and made it a lifetime requirement and left it to the discretion of the individual courts whether to justify whether to remove that limitation. And again, I've never seen it removed. Most states go far and above. It's just an insane prospect. But the Smith case in the United States Supreme Court revolved around whether the imposition constituted a criminal or civil issue. The court essentially ruled that the law sought to create a civil regulatory scheme, and therefore that made it civil, and therefore it was not criminal, it wasn't punitive. It essentially ruled that it was designed to track sex offenders for the purposes of civil order. The problem is, the Supreme Court went out of its way to find the regulation non-criminal. I mean, it's laughable. Read the law, read the case. I strongly encourage you to go back and read the case. Some of the excuses they came up with was the legal intent is enough to bypass cruel and unusual punishment. Remember what I said about Wicko? If a law, regardless of whether on its face it appears to be legitimate, if it's applied with a wicked hand, an evil eye, then it's unconstitutional. So if the intent, supposedly as written in the law, is to be civil regulatory, but is applied for the purposes of being punitive, then it does not meet the measure, and under Wicko it should be declared unconstitutional. The Supreme Court did not adhere to its own precedent. The law was actually in the criminal code of the state of Alaska. And the United States Supreme Court said just because it's in the criminal code does not make it a criminal law, a criminal offense. Excuse me? If something is in the criminal code that says if you commit this act, you are subject to this penalty, that makes it a crime. The Supreme Court said no. Just because it appears there doesn't mean it's a crime. They actually said that the application stemming from a criminal offense does not make it a punishment. In other words, they deliberately said that just because it's a penalty or something that attaches to someone because of a criminal offense does not in and of itself make it a punishment. Excuse me, if the only way to get it on a sex offender registry list or a violent offender registry list is to commit either a sex crime or a violent crime, it is a consequence of your conviction of your criminal act, and therefore it is a penalty. The United States Supreme Court disagreed. They said no, that we're going to let this law stand, and this is how we're going to let it stand. The reasoning and rationality we're going to use to let it stand. I mean, please. That is like me trying to explain why my socks are blue. They're blue because they're not pink. And just because they appear blue doesn't mean they are blue, just because they look blue. That's literally the rationality. Literally the rationale the United States Supreme Court used. The U.S. Supreme Court wanted to keep the law on the books. They wanted to keep the standard true for the entire United States because it was mandated by the United States Congress. Okay? Remember, it was mandated by them, it was signed into law by the President of the United States, and it was imposed upon the states. They had to comply or they would lose 10% of their block grant for criminal justice. Either do this or else. They strong-armed the states, and the states didn't argue it. They went along with it. The problem is, given the freedom from the leash, without any restrictions, the states have taken it so far and beyond what the original law mandated. Most states have wrapped up violent offenders into the sex offender registry. Many states make it mandatory to register for life, even though it's a 10-year minimum for most offenses. Some states allow for the petition to be relieved from it, like Montana. It's purely discretionary. There's no mandatory requirement. There's no right to it. The courts don't have to give it, and if the courts want to keep you under registry for the rest of your life, they absolutely can, and in the case of Montana, they absolutely do. Public perception has always been that sex offenders are the highest risk of recidivism. That's all propaganda. Statistics across the board refute that. Massive numbers of studies since this law has been imposed have shown just the opposite. In fact, the Bureau of Justice Statistics, a federal agency, in a report titled Recidivism of Sex Offenders Released from State Prison, a 9-year follow-up from 2005 to 2014, stated specifically that sex offenders were less likely to be arrested for any crime by a percent of 84% for others, 67% for sex offenders. And only 7.7% of those sex offenders reoffended for sex offenses. 7.7% recidivism rate. There is no other category in the Bureau of Justice Statistics that is single digit. It's the only one that's single digit. Everyone else, drug use, theft, even violent crimes, are all double digit. All double digit. The rationality, the public perception, the propaganda that changes the perceptions on this have made it to where even the group that is the least likely to reoffend is treated the most harshly, deprived the most, because it is a social taboo to be a sex offender. And I'm not defending sex offenders. I'm not saying that someone who goes out and rapes somebody should be granted clemency. I'm not saying that anybody that does something to a child should ever be given a free walk. They should be punished. They should be given criminal penalty. Absolutely. But should it be a lifetime offense? Should they have to register for the rest of their lives and resubject themselves to criminal offense if they slip up or they fail to do so? In my own case, the reason why this subject came up, I'm required to register every January. They send me a form in the mail. I fill it out, I take it to my local police station, and I file it. Required to. January passed this year, and I didn't get one. I didn't get one last year at all, by the way. I had to actually go, in the middle of February, I said, okay, I gotta go take care of this on my own because they're not sending me the form I'm supposed to have. This year, I just got it yesterday. I got it yesterday. I was watching my calendar, I was watching my mail, I was watching for it, knowing that it was supposed to be coming. With COVID, apparently, there is a problem with getting mail sent out of the state government. So we had delays this year. The letter was dated January 21st. I got it yesterday. And for the record, today is the 4th of February, so yesterday was the 3rd of February. So, and yes, this will be published on, this will actually be posted on the 5th. I record these the night before, as a reminder. But the idea being that essentially sex offenders and violent offenders have fallen into a disfavored category. And because they're disfavored, not because they pose a higher risk to society, not because they serve some kind of, it's necessary to protect the public from them more so than drug offenders or car thieves or whoever else, but because they're disfavored. They're seen in a negative light. And because of that, their civil liberties are stripped from them. Their civil liberties are expunged. They don't have any rights. The right to be free from or protected from cruel and unusual punishment, double jeopardy, due process, out the window. All because they get convicted of a crime that the public doesn't like. And they shouldn't like it. I'm not saying they should. But does that mean this person can never, ever, ever be rehabilitated? Does this mean this person is never entitled to return to society in any context? He should wear a scarlet letter for the rest of his life? Does it mean this person should forever be deprived any chance of advancement in management, in their jobs? Does it mean they should be deprived home? In Florida, people living homeless under a bridge because Florida has passed laws that say where sex offenders can live, and have expanded the distance so far from schools and public places that they are literally left homeless, sleeping under bridges. Not because they can't afford housing, because they're not allowed to live in housing. They're not allowed to seek shelter because of the laws that are so stringent. Remember, I'm not in any, and I have to keep going back to this point, I am not validating sex crimes. I am not saying they're okay. I'm not saying that you should not punish sex crimes or violent crimes. I'm not saying that. I'm a strong advocate of punishing them. But I think it has to be genuine and measured. It has to be appropriate for the crime. In my case, even if you take a devil's advocate position and ignore my protests of innocence, I was accused and convicted of touching a 13-year-old, not invading, not penetrating, not having sex with, touching a 13-year-old one time, depending upon which version of her story you go with. She told 6 different versions, between 5 seconds and maybe 15 seconds. For this 10 to 15 second, 5 to 15 second breach of ethics, of ethical conduct, I'm required to register for the rest of my life. And if I don't, I go back to prison. Where's the equality and balance? Where's the measured consequence here? Even if I were guilty, does it justify a lifetime consequence? And there's where you have to ask the question. And that's under the cruel and unusual punishment prohibitions of our own Constitution. It does not. I have not taken a life. I have not deprived somebody of any measure of their life. No ambulatory function. I haven't cut off someone's arm. I haven't shot them in the leg. I haven't done anything to cause them physical harm, even if you believe the allegation. 5 to 15 seconds. No threat of harm was ever alleged. No anything. Just supposedly I touched her. And I'm not defending it. If I had actually done that, and believe me, when I was first accused of it, I was like wondering if I'd fallen asleep and done something inappropriate in my sleep. It bothered me. It just, even knowing under the law that an involuntary act of something in your sleep is something you're not responsible for, I was sickened at the prospect. It wasn't until she started telling different versions of the story that I realized this didn't actually happen. My first thought was not she's lying. My first thought was, did I fall asleep and do something I didn't need to do? That was my first thought. Did I do something involuntarily? It wasn't until she started changing her stories that I realized this never happened. It couldn't have happened. Otherwise, her story would have stayed the same. My story has always stayed the same. I have no recollection of ever touching her in that capacity as I was accused. And I'm not defending sex offenders when I say this. I am saying this is the problem. Just because I'm classified as this, it gives the authorities the opportunity to track me for the rest of my life, to keep tabs on me where I am, where I'm living, where I might be working, what car I'm driving, what my email addresses are, what my web presences are, so they can track me and keep tabs on me, because they hide my political prisoner status under a label that's not applicable, because there's no legal capacity to hold me as a political prisoner in the United States. So they call it something else. They vilify me to the public. They shame me to the public. And they require me to register and tell them where I'm at, so they can come get me whenever they want to. The problem is that sex offenses include a litany of crimes that don't even constitute this. As I've mentioned, if you have your zipper down and you're walking around not realizing your zipper's down, someone's offended by that, you now have indecent exposure. It's a sex offense. You basically are given a lifetime sentence for something that may be 5 seconds of your life. And I'm not saying that, oh yeah, okay, I take a gun and I shoot somebody in 5 seconds, that person's dead. There are consequences that extend beyond a shooting someone dead, that extend way beyond that 5-second period. But if you're walking around with your pants down, if you look at somebody too long, if you touch somebody too long, if you touch somebody on the shoulder and say, hey, do you want to go to a movie sometime? Well, they don't want you to touch them. It's now a sex offense. Sexual assault, unwanted sexual contact for the purpose of sexual intent. It's a sex offense. The most inane things can be sex offenses, but universally, you're given a lifetime penalty for it. And I'm not saying that if somebody rapes a child, you probably do want to keep that person under tabs, but does it need to be a public registry? Why not just have it be law enforcement? Law enforcement can keep tabs on it. Law enforcement can know where you are. Those are the only people that really need to know where you are. Except public interest. If you actually have an offense that relates to that, and you move into a neighborhood where there's a whole bunch of children around, yeah, you probably do need to do a background check on that person and know that person has a history of doing exactly this. Again, we're talking about violent offense or level 3 sex offenders, people who do these incredibly harsh acts of crimes. Yeah, I can measure that to some degree, but it's a universal application across the board, and it's used to defy. But even somebody who commits a crime as heinous as raping a baby, he deserves the chance to be rehabilitated. And yeah, should law enforcement track where he is? Sure. Absolutely. Probably. Just to be safe. But they should also be tracked, just like they track where murderers go. They should track where car thieves are. They want to track where, maybe they want to make sure embezzlers aren't getting another Fortune 500 job. Come on. The rationality, if you're going to apply it to one, it's got to be applied equally across the board. It can't be desegregated or discriminated against. And that's the problem with these civil regulatory schemes, is they do that. They apply a standard to a select group, deprive that group of civil liberty for the rest of their lives. And yes, this is a lifetime punishment. It absolutely is. You cannot call it a civil regulatory scheme because it defies the rights. The individual right, there's a standard in American law that says that the rights of the individual exceed the rights of the masses. The rights of the individual, your right to free speech, your right, I have the right to say, I don't like something in American society, and regardless of whether every other person in the country doesn't like it, I still have the right to say it. Bill Willingham, who was a comic book creator, said something back in the 90s. I always quote this. He said, I never get the quote exactly right, but basically he said, I personally am opposed to child pornography, bestiality, any of those concepts. It makes me sick. But I'll be the first person to stand in line to defend somebody's right to write about it. If somebody wants to write a story about molestation or about bestiality, Bill Willingham's basic purpose is saying they have the right to express themselves in written form and say whatever they want to say. Now, if they're talking about having sex with a specific person underage or harming animals, like I went out in my yard and I had sex with my dog Bo, and they actually have a dog Bo, and they're actually describing actual acts of which they have committed. No, obviously. But for the purposes of fictional recreation, people have the right to express themselves, and that was Bill Willingham's point. And that's what I'm saying here, is that you have the right, any individual has the right to speak out and say whatever they want and do whatever they want, because this is supposed to be a democracy or a civil republic. But there's no civility or republic or even democracy if you take a group of people and say, you have no right to do this, because we say you don't. I'm going to give you a quote. In 2019, Michigan Attorney General Dana Nessel wrote a brief, and in her brief, she's arguing against her state's sex offender registries. Yeah, believe it, there are some states out there are some enlightened politicians who actually recognize the problem here. This is coming from the Michigan Attorney General Dana Nessel in 2019. She said, sex offender registrants, quote, are no longer simply shamed in the public square of one's own community. They are shamed in the eyes of their county, their state, their nation, and our global economy, the world. End quote. And she's not wrong. Sex offenders and violent offenders who are forced to register and this information becomes public, they are forced to declare their shame for the world. For the world. And no one actually has to say the reason why they discriminated against them was because they found them on a registry. No one has to. They just simply use their own personal prejudice and find another reason not to hire them, not to allow them to live somewhere, not allow them to associate or have membership, whatever. This is a deliberate and willful infliction of harm. It is punitive. It is punishment for commission of a crime. And it is a lifetime penalty, punishable in most states as a felony if you violate it. In the movie Minority Report, people are punished for crimes they haven't committed yet. Doesn't this sound like that? Registration in advance of committing a new crime, just in case one happens. Register with us just in case you commit a new crime. Now keep in mind, only 7% of these people who are being forced to register statistically reoffend. 7.7%, closer to 8%. You're talking 8 people out of every 100 you're required to read a lifetime penalty when 92% will not reoffend. Remember, I just said this in my last podcast. Benjamin Franklin's quote that it is better that 100 guilty people go unpunished than one innocent person suffer. Now you're talking about 92 people suffering for 8 people that might offend. 92 people for 8. Talk about a gross flip of the scale. Not 100 guilty for 1 innocent. We're talking 8 guilty for 92 innocent. Gross misapplication, gross disproportionate. And as I mentioned, this is exactly why, this is one of the many reasons why they chose this offense to go after me with. Because not only does it subject me to public shame and scorn and disenfranchisement, but it requires me to tell the very government that I am speaking out against, that is holding me as a political prisoner, to tell them where I am at all times. Where I sleep, what I drive, where I work, what my social presence is on the internet, which, by the way, the Ninth Circuit Court has actually said that's illegal. Once again, they ruled that in California. No mandate, even though Montana is within the Ninth District, federal Ninth District court system, they haven't come back and required Montana to receive that. An individual action would have to be brought in Montana and asked to enforce the Ninth Circuit Court's ruling to actually have that happen. But Montana, as I've mentioned before, it'll come down to Montana enforcing Montana, the appellate court enforcing Montana, and the United States Supreme Court not hearing the case. At a certain point, you just get tired of fighting. You can't fight every war. Even though it's been ruled unconstitutional, Montana does it because Montana can. And they do. And in this case, Montana takes a pre-existing standard and uses it so grossly inappropriately. Let's go ahead and use this as a mandate to go ahead and track people we don't like. Let's go ahead and use this to track political dissidents, people we don't want to be free. And they know they're being tracked, and therefore we can keep a thumb on them. When are we free? Thank you for listening to me tonight. As always, if you're watching this on any other platform than YouTube, please, for some reason you're not on the platform, you're not seeing the text attached to this video, please visit us on monspiracy.podbean.com, which is where this podcast originates. Again, if you are watching this on YouTube, please like and subscribe. Share this with your friends, associates, post it on public forums, post it in social media, Twitter, Facebook. Remember, I'm not allowed on Facebook. I can't post these videos on Facebook. One of the many restrictions I'm under. So please, post for me. Go out there and let this information be heard. I thank you for your time, and please, above all else, in this world we have today, please be safe, and whenever possible, please be free. Thank you.